Get it.
The most important lawsuit in America right now, and perhaps the free world.
Oh my god. Oh my god. Oh, fucking cringe. Jesus Christ. Right off the fucking bat. The most important lawsuit in the free world. I'm ready.
Is Prager University versus YouTube. You might consider this a grandiose statement.
Yeah.
Especially since I'm the lead attorney for PragerU. I assure you, it's not.
Oh, wow.
That's because this case is about the most fundamental freedom Americans have.
The ability to make propaganda YouTube channels without having their content occasionally demonetized for doing political shit. The same way everyone else's content is.
Freedom of speech, as enunciated in the First Amendment to the United States Constitution.
Which has absolutely nothing to do with how businesses treat you when you use their platforms. Oops. Sorry, buddy. I thought you were some kind of lawyer. You don't know how the Constitution works? It protects you from government censorship, not from corporate censorship.
All our freedoms, the very concept of freedom, springs from this right. Lose it, and we're no longer free, not as individuals and not as a nation. I'm not willing to accept that. PragerU doesn't accept that, and you shouldn't either. Okay, so how did we get into this situation? A little background.
Tell me.
PragerU is what is called a 501c3, a nonprofit educational media company.
And also a YouTube channel. Let's, I know you guys never actually say that out loud, but that's what you are.
It's known primarily for its 5-minute videos. In 2016, viewers began to notice that certain PragerU videos were no longer available. YouTube had placed them on its restricted list, which prevents the videos from playing on computers using content filters to screen out violence and pornography.
Oh, so these videos weren't... Ooh, darn. So these videos weren't even deleted, which is what you imply with the little, sorry, this video can't be found thing. Instead, what it is that it is being restricted by the content filters that also screen for extremist political stuff and violence, which is what PragerU promotes.
From playing on computers using content filters.
Right now, so literally what they're saying is some of our videos got placed on content filters, like behind content filters. That's literally what they're saying.
To screen out violence and pornography.
Honestly, under 18s probably shouldn't be watching PragerU anyway, huh?
PragerU assumed this was simply a case of bad algorithms. But YouTube said no. Each restricted video had been reviewed by a walking, talking human. The list included such diverse titles as, Are the Police Racist?
You mean a highly political video that I remember watching, one in which you indicate that the disproportionate police brutality against African Americans is their own fault? I can understand why that might get locked behind a content filter, especially since the content filter is not just for violence and not just for pornography, but is also for heavy political content. I, myself, have been placed behind some of those filters sometimes.
By Heather McDonald, Israel's legal founding.
You mean glossing over the genocide of the Palestinian people? I can understand why that might be extreme political content that some people might want to place behind a content filter.
By Alan Dershowitz, and even a video on the 10 Commandments by Dennis Prager.
Yeah, heavy religious content? I mean, I don't know, I haven't watched this video. It's probably dumb and gay because religion is dumb and gay. What are you going to do?
YouTube deemed each one unsuitable for young people.
Yeah.
Treating these videos the same as they would, say, for ones containing pornography or excessive violence.
Or heavy political content, like every other political channel. Yep. Yep, just like all other political channels. So keep in mind so far, when this dumb fuck came up here and he was like, this is probably the most important lawsuit in the free world right now. What he meant was that his highly political YouTube channel was getting placed behind age-restricted content filters meant to filter out highly political YouTube videos. That's what we're getting from this. That's the lawsuit. That's the most important lawsuit in the free world. Damn. To be fair, this doesn't happen with milquetoast big media libcucks. Well, a lot of those big media libcucks are actually working through like studios, for one, and for two, yeah, big milquetoast big media libcucks don't advocate for genocide or downplay racism.
Keep in mind, this is PragerU we're talking about, as Main Street as you can get.
Oh man, let him gaslight you like that. Oh baby. I can imagine Nick Fuentes saying the exact same thing, or James Alsop, or like Richard Spencer, or Sargon of Akkad, you know, and just remember, this is Paul Joseph Watson, and just remember, this is what does he do again? His channel is just called Paul Joseph Watson, right? It's me, Paul Joseph Watson. Remember, this is as mainstream milquetoast as it gets. But they censored me anyway. Imagine my shock.
And that ultimately turns out to be the issue. PragerU's center-right content. Many of their videos, by the way, have no political theme at all.
Wait, what are these videos that you say have no political theme right here? Okay, no political theme. So here's Jocko Willink's video on discipline. We watched that one on stream. Here's fucking history of the Israeli people. That's not political, apparently. Here's the fucking founding of America. How are these not political?
Their videos, by the way, have no political theme at all.
The dirty truth, in my opinion, there's fucking Martin Luther King Jr. No political theme at all. Look at all of these guys. Look at all these apolitical videos I've got in my hands. Fucking videos about how racism isn't real, or about how Israelis have a birthright entitlement to their ancestral homeland, and Palestinian people are subhuman. How do these keep falling out? Oh God. Oh man. Sorry. All these apolitical videos. Let me just take these over to evidence pile A for our big, incredibly important lawsuit against YouTube.
Offends YouTube sensibilities.
Damn right.
In other words, the videos aren't being restricted to protect young people from inappropriate content.
They are.
They're being restricted to protect young people from ideas YouTube disagrees with.
Yeah, that's inappropriate content. You could say the exact same thing about jihadi videos, except PragerU is way more damaging to America than any jihadi ever could be.
We didn't want to sue. We tried to reach an accommodation. But when YouTube wouldn't take the offending videos off the restricted list, there are now 100 on that list, we had no other option. YouTube was infringing on our right to free speech.
One more quick reminder, don't let this clown fool you. It's funny, this guy's a lawyer and he's being paid to lie to you right now. And he knows this lawsuit isn't going to go anywhere. It's just a publicity stunt, like it all is. The First Amendment of the United States Bill of Rights does not protect you from being censored or placed on restricted lists by corporations when you are using their platform. They are private agencies, and they are free to filter the content you put on their platform however they choose to. That is their legal right. In no way, shape, or form are putting PragerU's videos behind an age restriction filter a violation of their First Amendment rights.
We filed in federal court in late 2017, and thereafter in California state court. Wait a second, you might say. YouTube, which is owned by Google, is a private company.
Oh, no.
Can't they do anything they want?
Public Commons?
The answer is yes and no.
Oh.
Yes,
confusing.
if they are a publisher. No.
Yeah. There we go. There it is. Yes, if they're a publisher, no, if they're a platform. This is a lie that they're trying to push to try and form some imaginary distinction between publisher and platform. It's completely not true, in the slightest. So what they're going to say is that if you're a platform, you can't moderate anything ever, because if you moderate, that means you're publishing, and publishing has a different set of legal rules. This is not true at all. All content platforms, all of them, Twitter, YouTube, have a right to have a TOS. And if they have a TOS, that means they have a right to enforce that TOS, which sometimes might mean the removal or filtering of content. There is no meaningful distinction between a publisher and a platform in the way they're using it, because they are using it in the way a liar would use that distinction. In reality, a publisher has direct authorial control over each and everything that puts out. Things are not put out without the publisher's permission, whereas a platform is just a service people can use to upload their shit. YouTube doesn't check every single video that comes up, not even fucking close, but they use algorithms to apply broad bans, deletes, and content restrictions as a way of moderating their content and keeping it more or less in line. PragerU would have absolutely no problem with this if these restrictions were being placed, say, on jihadi videos, like if somebody was uploading like ISIS propaganda videos to YouTube. PragerU would have absolutely no problem with YouTube putting this behind a restricted list, or even YouTube deleting those videos, in spite of the fact that that is the exact position PragerU currently finds itself in. They are hypocrites and they are lying. It's very deliberate, and they're doing it for publicity. That's why they made a video out of it. I mean, I don't need to tell you how crass it is to sue YouTube over some of your videos getting put on a restricted list and then make a YouTube video to millions of people about it, where you say that your lawsuit is the most important one currently in the free world. I have the congressional research report on the issue if you want to look at it. I appreciate the offer, Ali Akais, but I imagine it's supremely boring.
If they are a public forum. So what's the difference? This gets right to the nub of the matter. A publisher chooses the content that resides on its site. The New York Times is a perfect example. You can't write a story and just expect the New York Times to publish it. The Times chooses what appears on its pages or website. And if they publish a story that contains a malicious lie or violates copyright law, they can be sued. PragerU is also a publisher. It decides what material gets placed on its website. Most sites are publishers. In contrast, a public forum, which can be a physical location like the classic town square or a shopping mall, or a virtual location like a website.
No, they're confusing the language here again. This is not what a public forum means. A public forum is a public space. YouTube is privately owned. It's not a public forum. And also, YouTube, unlike New York Times or PragerU or whatever, does not own all of the content uploaded to it, another way in which it is a platform rather than a publisher. When I upload my videos to YouTube, they do not automatically become the, property of YouTube.
Is a place that must allow individuals and organizations to exercise their free speech rights.
No, that is factually not true, and not in any way, shape, or form. What is that supposed to be, a building? If that building is privately owned, the people who own that building can throw you out if they don't like what you're saying. This is the most bald-faced lie about the First Amendment that I have ever seen, like in my entire life. You can get kicked out of any building if the people who reside in that building, who own that building, don't like what you're saying. This is a completely asinine distinction, and even in the distinction where they're creating the rules of their language, where they're lying about what these terms mean, they still can't create something that's consistent.
YouTube is an example of a public forum. In fact,
No, actually, because it is a private service owned by a private company. They do not pick and choose what gets put on there. They do not take ownership over everything that is put on there. And YouTube cannot be sued for the content that is uploaded there. If someone wants to upload something pirated, as long as they do due diligence to ensure that content doesn't propagate on their platform. That's why they have the Content ID system.
YouTube describes itself as a public forum.
Not in the legal sense. They describe themselves as a public forum because it's good for their branding. That doesn't necessarily mean, that does not mean that they that the people who upload their shit to YouTube benefit from First Amendment protections.
You make a video, YouTube hosts it, and anyone with an internet connection can watch it. Facebook is also a public forum, and so is Twitter. Here's why this is so important.
Again, no. In all three of these websites, they are privately owned. For all three of these websites, they do not own the content that you put on there. For all three of these websites, they do not individually pick and choose what gets put on there. They just are free to upload for anyone. Anyone can put up there whatever they want. And for all three of these websites, they have TOS. You guys realize that right now, what PragerU is advocating is that if you have any site that allows other users to upload content, if you enforce any sort of terms of service, you're violating their First Amendment rights. You realize that's the logical extension of what PragerU is saying. Because if after all, if the First Amendment applies to YouTube or Twitter or what have you, then deleting a tweet for harassing other people or banning a video for nudity, those are violations of TOS, sure, but to delete those things, that's a violation of their freedom of speech. They're literally saying that you cannot have any terms of service on a website in order for it to be a public forum. So, okay. Yeah, child pornography? Oh, I'm sorry. Uploading child pornography to our servers, well, we wouldn't want to, treat ourselves like a publisher, so I think we'll let you have that.
A public forum under Section 230 of the Communications Decency Act, a law co-sponsored by Democrats and Republicans and passed by Congress in 1996, is not subject to liability for content placed on its site.
Except that's not the definition of public forum that precludes the existence of free speech. In this instance, them being a public forum is a term used to describe their lack of liability over the things that they have published on their site. You, PragerU, are making the opposite claim, that because YouTube does have liability over what they put up on their site, they are censoring you, and therefore this is a violation of your First Amendment rights.
If someone posts a video about how to build a bomb,
we should ally with the right on this. We could subversively get them to support socialism. No, McChicken, that's a brainlet take. These people know exactly what they're doing. They're not accidentally advocating for socialism. They're advocating for state control of industries so they can't be stopped on it, so they can use the power of the state to propagate their propaganda without worrying about violating TOS. This is not, they're accidentally doing socialism. This is them very, very deliberately invoking the language of state control to consolidate political power, and we should not ally with them on this.
Writes a threatening comment, the public forum website cannot be held legally responsible for that content. That's a good thing. It gives YouTube and other public forums the chance to host a wide variety of material, from nature videos to political diatribes, without fear of being sued. And it worked. And then it didn't. A few years ago, the social media giants, Google, Facebook, YouTube, and Twitter, started to behave not like public forums, but like publishers. They stopped following Section 230, which specifically requires that these websites promote a true diversity of political discourse.
Yeah, they do. Political content is demonetized and put behind content blockers.
And began to judge content by their own political and social criteria.
This only works if you stand by the lie that there's any sort of neutral objectivity that you can judge videos from. This is an abject fucking lie. At the end of the day, no matter what PragerU would like to lie to you about, the fact remains this. YouTube, Facebook, Twitter, Google, these are called public forums in a sense that refers to their lack of liability for content published there, not because the First Amendment protections apply to them. You'll notice, by the way, that at no point in this video, literally no point in this video, did they support their claim that that First Amendment protections apply to these websites. Because they don't. That's factually incorrect. They said, well, public spaces like outside or at a library, they respect your First Amendment rights there. Also public spaces like Google. Not actually. No. No, actually. Not true. No. They don't have to respect your First Amendment rights. If they did, there would be no such thing as terms of service on any website, because enforcing terms of service necessarily requires the corporation to act in ways that the state would not be permitted to act. Do you understand that? You realize if you go to a grocery store and you start running about like shouting that the manager is a cuck, fuck everything, you can do this in public if you'd like, though you might get slapped with unruly behavior. But they could just kick you out. They can kick you out for anything, as long as it's not a protected class thing. You'll notice, by the way, that political affiliation is not one of the protected classes in the United States of America. Perfectly legal for a business to discriminate against you, if for you being a fascist or a Nazi or a Republican or a Democrat. Vosh, the link I posted is an overview of the clause. What he said made no fucking sense. This is not surprising to me. Let me check my DMs. What link? What post? What link post? Post link? Here we go. Let's see. What is Section 230 of the Communication Decency Act? So this is the act right here that that PragerU claims YouTube is violated. You'll notice, by the way, again, at no point did they substantiate their claim that any of these websites have to be held to First Amendment protection standards. Let's see. Section 230 of the Communications Decency Act of 1996, common name for Title V of the Telecommunications piece of internet legislation, provides immunity from liability from providers interacting computer services, publish information provided by others. Immunity clause, no to treat as publisher or speaker any information. It's a content provider. Analyzing court three-prong test. A defendant must satisfy each of the three prongs to be immune from liability. This has nothing to do with the First Amendment, by the way. First, the defendant must be a provider or user of an interactive computer service. A. Second, cause of action served by the plaintiff must view the defendant as the publisher or speaker of the harmful issue in question. Okay. Third, the information must be provided by another information content provider. Thus, the defendant was information. Okay. This is irrelevant. Concerns. Acting as broad legislation. Still somewhere. Interactive computer service providers might choose to severely restrict the number and type of messages posted. The court held that Congress considered the weight of the speech interests implicated and chose to immunize service providers to avoid any such restrictive effect. Court ruled that it's 100% okay. Oh, God. Court ruled it's 100% okay for interactive service providers to severely restrict the number and type of certain messages posted. Interesting. Interesting. Significant court cases that determine how the CDA is interpreted. Section. Roommates was not a passive publisher of the content. Discriminatory. That has more to do with liability, civil damage. Provider. Protection. Interesting. So we just read the entirety of the summary of the Section 230 of the Communication Decency Act, and nowhere in there did it say that a service's protection from outside civil liability in any way, shape, or form hinges upon them providing a balance of political opinions. Wow. Fascinating. So that was a complete lie. So not only were they lying when they conflated public spaces in outside with public spaces in YouTube and how it's regarded by the Communications Act, not only did they lie about them being subject to First Amendment protections, wow, but damn, they also lied about a provision in that Communications Act which had anything to do with objective political like neutrality. Yeah, whoa, whoa, amazing. Damn. Jumping all over the place with this one. God.
In other words, the social media giants want it both ways. They want the protections of a public forum and the editorial control of a publisher.
Damn, Sup, we just read the thing and nowhere did it say that the public forum status is in any way, shape, or form exempted when you do TOS protections or TOS enforcement within your site. And we took a look at the prerequisites for what it means to have these protections, and nothing about it had anything to do whatsoever with what this video is saying it has to do with. We can go over it one more time. In fact, we should. One more time, folks. One more time. Right here. It says right here. In order to analyze the availability of the immunity offered by this provision, so this is whether or not Section 230 applies, courts generally apply a three-prong test. A defendant must satisfy each of the three prongs to be immune from liability. You'll notice, by the way, this has nothing to do, literally nothing to do with the First Amendment. This has everything to do with protection, like from civil liability. Okay? First, the defendant must be a provider or user of an interactive computer service. Check for all. Second, the cause of action asserted by the plaintiff must view the defendant as the publisher or speaker of that harmful information at issue. So that means the person filing the case must view the YouTube, in this case, as the publisher or speaker of that info. Third, the information must be provided by another information-centered content provider. That is to say, it wasn't provided by YouTube itself, it was provided by the person who uploaded it to YouTube. That's what determines the whatever fits under here, has nothing to do with the First Amendment, and YouTube meets every requirement. It's completely irrelevant to what they're talking. This First Amendment shit, this political neutrality shit, literally nothing to do with anything. They just made it up. And the person who made it up, this lawyer, knew he made it up. He is lying to make money.
We're fine if they're a publisher, and we're fine if they're a public forum. They just can't be both. If we win our legal action, YouTube will have to return to the way things were when they started. That's freedom. But if we lose...
Freedom is filing fallacious lawsuits. Bunk lawsuits against the government to force a private corporation to adhere to a set of legal standards that are not written out in any legislation and you just made up for the purpose of this video.
YouTube gets to act as a publisher while pretending to be a public forum. That would mean much less freedom and then eventually no freedom.
Damn.
Because the most powerful...
No freedom at all? Holy shit, this truly is the most important... civil rights case in the history of our time. This dude's fighting to keep us from 1984.
Powerful internet sites on Earth will determine what you see and what you don't. I'm Eric George, managing partner, Brown George Ross, for Prager University.
I will never stop being amused by the fact that conservatives spent decades railing against any kind of government control of private industry, and all it took was for them to start making a little bit less money on their YouTube videos, and the entire party is now like rambling on and on about the necessity of literally state control of private enterprise. That's a good-ass meme right there.